It's a great pleasure to be here. Thank you for having me. And in the run of sexy topics that this panel is dealing with, I'm dealing with the sexiest of all, gas pricing disputes. And I promise you it is better than it sounds. Gas pricing disputes are a bit of an anomaly in arbitration. And the reason for that, they are quite an unusual beast. The reason for that is that they do not pit one party against the other because of a breach of contract. A gas price review arbitration has to do with exactly what it says. It is the price of the supply of gas, and that price historically is usually pegged to an index, and historically that index was oil, so Brent, for example, the price of oil. And for historical reasons, because gas was at the time frequently extracted at the same time as oil, together with oil, and so the costs and the infrastructure were very similar. There were historically no real pricing hubs for gas. But that has all changed in the past 20 years. And in the past 20 years, we now have pricing hubs that are, trading hubs that are specifically for gas. And of course, the price of oil has gone down and up. And so as a result, those parties to gas supply agreements have found themselves with very onerous pricing mechanisms when, in fact, there could have been a cheaper option if they had provided for another peg for the price of gas, for example, a European hub. And so we have seen quite a few of these agreements being brought to arbitration, and they are usually brought to arbitration rather than the courts because this is one of the areas that is the last bastion of complete confidentiality. Those pricing formulae are very valuable to the companies that devise them, and it's a very competitive market, so you will not see those cases brought before state courts unless, of course, you have a challenge to one of the arbitral awards, in which case it bursts out in the open, and everybody looks at these cases like they are the manna because there are so few of them. So that's a little bit of the landscape. So what is important to know is that these are not breach of contract cases. So neither party is at fault. It is just that for example, the price of oil has changed so much since the negotiation of the contract that one party feels that they're getting a raw deal and they want to have a change either in the formula or for an arbitration tribunal to decide what should happen to this price, how the formula should be altered. It is usually, they are not very frequent in the life of a contract. These are contracts that last a very long time, 25 years or so, and they involve, as you might imagine, hundreds of millions of dollars, if not billions, and they don't involve a termination of a contractual relationship either. So it's quite important to realize that after the decision of the tribunal, the parties have to continue to live together, often for many, many years. So what does that mean for the tribunal? Yes, it means that you have a dispute that is more commercial and technical than legal. It's not, there is obviously a governing law to these agreements, but at the end of the day, the decision that you're asked to take as a tribunal to alter a price formula is very much an expert witness matter rather than applying the law. And the parties are usually a lot more expert than the tribunal at doing this. So what would a tribunal looking at this with experienced parties who want to carry on doing business together on a fair manner, what would you expect? You would expect two parties to come to the tribunal not being so polarized, not drawing guns at each other, but saying to the tribunal, look, we've tried to talk this out. We can't reach agreement. Please help us. And so the tribunal finds itself in an unusual position of not saying you're right, you're wrong, but trying to find a fair way forward. Now, the reality of these disputes, unfortunately, is quite different. And the reality of these disputes is that counsel usually approach them as being a straight commercial arbitration dispute. and they come in with experts that say the exact opposite of one another. Often, and I have seen this, refuse to meet in the room to try to streamline the issues in breach of an order of the arbitral tribunal because the parties are at war. And so the tribunal finds itself very isolated, having to decide on a technical matter with experts that contradict each other, and at the same time very much aware of the fact that those parties need a decision in order to go forward for another 15 years. The reality is that also that there are two other things. Arbitration is very much an adjudicatory system. You have to decide this, this is not a mediation, essentially. It is all, however, a flexible process, and so therefore it can suit itself to these disputes. The other problem is the language of those price review clauses. Because the parties, when they negotiate those clauses and those prices, do not know the future, they do not know what will happen to the index that they choose, they often have a language that is very open-textured. And often you will have these clauses that I would say is probably rule number one of never doing this when you draft a contract, which is the price should end up being fair and equitable. And that, my friends, is the guideline that the tribunal has to decide these multi-million-dollar disputes. So, which is why when those awards do come out, and for challenge or otherwise, parties and the public are very surprised by what many of these awards say, because the tribunal is often faced with a very polarized landscape and has to essentially go back into its room and decide in its conscience of what it considers as a tribunal as fair and equitable, rather than what the parties consider as fair and equitable. So that's why it's a little bit of an unusual, it makes also for very, very challenging disputes. So I'm just going to focus quickly before I stop on one of those cases that has come out, and it came out, it's starting to be a little bit old now, but it's called Gas Natural versus Atlantic LNG. And in this case, to make a long story short, I'm not going to bore you with the facts, but essentially what the tribunal did is it came out with its own solution. Party A was saying we want to keep the oil index because that's what we agreed. Party B was saying, no, we want to get rid of the oil index because it's no longer fair. And the tribunal decided to come up with its own solution, which was some sort of a two-part solution that no party had pleaded and no party has asked for. And why? Look at the wording of that lovely contract. That's the price clause, and it says, I'm going to read it at length because it's worth it. If at any time either party considers that economic circumstances in Spain beyond the control of the parties have substantially changed, then such party may request that the party should forthwith enter into a negotiation to determine whether or not changed circumstances exist and justify a revision of the contract price provision and seek agreement on a fair and equitable revision of the contract price. And so the tribunal considered, having two parties who did not agree on anything, considered that fair and equitable meant choosing neither party's position and coming up with its own. Now, that does not make arbitration very attractive because it becomes an unpredictable exercise, and parties don't like it. However, they could help themselves by not embattling the tribunal with experts that cannot agree on anything. They could have one or two areas of disagreement, but really, I think it's not in the party's best interests to come to the tribunal with evidence that is completely at odds, because then the tribunal is left to its own devices, and heaven knows what three lawyers are going to do with a formula that is quite complex. So a few lessons that I've learned the hard way. Remember what you want the price review process to achieve. No one is at fault. You want a readjustment. You don't want blame. And for that reason, really what you should do ideally as a party is to say, take the tribunal through what you consider on the basis of commercial considerations would be fair and equitable, and provide guidance and make sure that the tribunal has a very determined mandate so that it doesn't go off on a tangent of its own just because there are no other options. It is also quite important to choose your players carefully, choosing arbitrators, counsel, and experts that understand the reality of this, that do not treat this as a breach of contract or as an investment claim for that matter. And so that you make sure that you have something that you can live with commercially. And it has been suggested that perhaps what is called baseball arbitration, which is essentially where each party gives the tribunal a sealed envelope with the number that it would like to have, and then the tribunal has to choose between those two numbers and not come up with one of its own. It has been suggested that perhaps those disputes would benefit from baseball arbitration. However, it's also been said that because the price formula is a package nature and it's quite it has quite a few layers. Probably an either-or approach is probably not fair and equitable, and query whether baseball arbitration and the choice between two numbers would actually meet the criterion of fair and equitable as a matter of law. These are open questions, and this is where I end my sexy topic. Thank you.